Hello, good evening, good evening. Good evening, everybody there. We're going to have the second half of the lecture. Okay, I'm not quite sure whether on this occasion we will again encounter any technical problems. Okay, I try to switch from the tablet into the mobile phone. Okay, they're using also another mobile phone. In fact, I'm now using two mobile phones, iPhone for recording and also Samsung Galaxy for uh, broadcasting live on Facebook. Okay, not quite sure whether we will encounter any more technical problems. Hopefully not. Okay, we had just had the first half of the lecture on the formation of contract. Okay, and as I have mentioned, we will make available that lecture file on YouTube. Okay, I have recorded the file and I'm going to upload the file onto YouTube, but it will normally take some time for YouTube to approve the content of that file before it is ready for viewing by the public. Okay, so hopefully you will be able to view that file, tonight, maybe in the middle of the night. Okay, at the latest by tomorrow. Okay, we will continue the lecture. Okay, this is the second half of the lecture. Again, it is on the formation of the contract. Okay, formation of a contract. Okay, let me just now proceed to the desk. Okay, for the papers of my lecturing. Okay. Again, hello, good evening again. Okay, I'm not quite sure whether you are still there or not for the purpose of our online teaching. Okay, our online teaching seems to encounter a lot of trouble. Okay, sometimes the voice cannot be heard by you. The audio signal seems to have something wrong. Okay, sometimes the picture becomes blurred. Okay, I don't know why. I don't know because it is because of the technical problem on the part of Facebook itself, or it is a technical problem resulting from the internet. I have, as mentioned, recorded my lecture also. Okay, using the mobile phone, and the recorded file will be made available for your viewing very soon. Okay, this now it is awaiting YouTube approval. It will take some time. Okay, you should be able to view that file very soon. Okay, sorry for the technical problems which we have encountered in the first half of the lecture. So that this is the second half of the lecture, but when you miss the first half, then it might be a little bit hard for you to follow the second half. Okay, until you have viewed the first half of the lecture. But in order to enable you to understand the lecture in the second half, I'm going to give you a very brief account of the first half of the lecture. Okay, in the first half of the lecture, we have talked about the formation of the contract. We have seen that a contract, according to the provisions in the CiSG, okay, a contract is formed by the meeting of the minds. Okay, that means that one person needs to make an offer and the other one needs to make an acceptance. Okay, so that the meeting of the minds, it is in the sense that an acceptance meets the offer. Okay, and the acceptance must match the offer completely. If an acceptance differs from the offer in any respect, okay, that is considered as an unqualified acceptance, so that the contract cannot be formed. Okay, and I have also in the first half of my lecture told you that some countries, they have the formal requirements. In some country, they have the law, okay, saying that when some contracts need to be made in writing, some contracts need to be made, need to be evidenced by needs to be supported by written evidence. Okay, some contract needs to be signed. Okay, so those are the formal requirements. Okay, the CiSG is based upon the freedom from form. Okay, the freedom from form rules. That means that a contract can be formed without any formal requirement. A contract can be formed, okay, without having to be made in writing, without having to be supported by written evidence, without having to be signed. Okay, so that is the principle contained in Article 11. Okay, if you look at Article 11, okay, a contract of sale need not be concluded in or evidenced by writing, and is not subject to subject to any other requirement as to form. It may be proved by any means, including witnesses. Okay, so I have also in our first half of the lecture, okay, told you that the reason behind the freedom from form principle is that, okay, there may be, okay, some the modern means of communications whereby a contract can be made, okay, that in any way, okay, that in order to suit the party's convenience. Okay, so that's why the CiSG does not require the contract to be supported by any formal formal requirement. Okay, so the contract can be formed even verbally or sometimes even by conduct. And we have also seen, okay, in my first half of the lecture that, okay, that there are cases in which contracts were formed, okay, by conduct. Okay, one of the cases, okay, is in this case where the contract was signed only by by the buyer. It was not signed by the seller, but the thing is that the seller delivered the goods to the buyer. It was here that the act of delivering of the goods to the buyer, it was the conduct, I mean, showing showing the consent, okay, of the seller, okay, consent to the contract, so that in this case a contract could be formed, right? So that if you want the details, okay, you have to go to view, okay, my lecture in the first half, okay, which is going to be available on YouTube very soon, okay. And I also tell you that some countries, okay, they have in their own law that some contracts, they have in their own law some form requirements under which some contracts need to be in writing, some contract need to be supported by written evidence, or some contracts may some contract need to be signed. Okay, so CiSG allows those countries to declare a declaration for reservation. Okay, so if they want some contracts to be subject to some form requirements, okay, under their domestic law, okay, under their own law, they can just make the reservation. Okay, and if they make reservations, that means that, okay, a contract which is made can be enforceable only when it is in compliance with the formal requirement in the domestic law domain of their own country. Okay, we have seen this one, and the reservation, okay, the permission for reservation, it is contained in the Article 12 of the CiSG, and we have also seen different ways of interpretation, of the Article 12. Okay, that we have seen Will 1 and Will 2 with respect to the reservations, okay, made under Article 12. Okay, so if you are interested in that, you can just follow my lecture in the first half. Okay, the first half of the lecture on YouTube. Okay, and we have seen the nature of an offer. In order for something to be an offer, okay, it has to have the elements or the two elements regarding sufficient definiteness, and elements the element the regarding the intention of the offeror to be bound with respect to the first element, element of sufficient definiteness. Okay, that we can see that the definiteness is satisfied when there is the indication of the goods, and also when there is a fixing of the quantity and the price, or the parties make provision for determining the quantity and the price. Okay, so that is dealt with, okay, in the first half of the lecture. And we have also seen the nature of an acceptance. Okay, an acceptance must be something which indicate assent to an offer. Okay, and we have seen that CiSG sets the point of time at which an offer and acceptance will take effect. Okay, an offer or acceptance will take effect at the time when it reaches the other party. An offer will be effective when it reaches the offeree. Similarly, an acceptance will be effective when it reaches the offeror. Okay, so that is what has been explained to you in the first half of my lecture. Now we are moving forward to the second half of the lecture. Okay, in the second half of the lecture, we will see the ending legal effect of an offer. Okay, when an offer has been made, then an offer will cease to have effect. Okay, so CiSG sets the term at which when an offer may cease to have effect. Okay, that is going to be explained to you very, very soon. Okay, in a few seconds. But before going to our discussion on this, let me just go and have a look at what is on the screen. Okay, in order to make sure that nothing goes wrong in the course of my lecture. Okay, I'm going to have a check on the mobile phone. Okay, to make sure that everything goes on all right. Okay, all right. Now with respect to the recording device, it is fine. Okay, and according to the other device with by which my lecture is broadcast live on the Facebook, it is on say fine. Okay, I think that you can still see me now. Okay, I can even see Panisa, okay, in this room, and I also see Nguyen, okay, from I hope they're from Vietnam, right? Also watching this video right now. Okay, so far so good. Okay, if I am not mistaken, right? I get a feeling that in the picture seem to be a little bit blurry. Okay, on my the mobile phone. Okay, but that might be because I just try to try to get my mobile phone to cool, okay, by keeping it in the fridge for some minutes. Okay, because when I just use my iPhone for recording my video, okay, it seems to be a little bit heated. Okay, so I try to reduce the heat by putting my mobile phone in the fridge for a few minutes. Okay, so maybe there is somewhat there is something which makes my lens, okay, a little bit blur. Okay, so sorry about that, but I hope that you can see, okay, the picture, okay, quite reasonably. Okay, now let me go back to my desk, okay, in order to continue my lecture. All right. So let's say that let's say we have A and B again. Okay, for simplicity, okay, we just use the A and B, okay, as the parties to the agreement. Okay, when A makes an offer to B, A's offer may cease to have effect. Okay, at two stages. Okay, CiSG makes a mention of two words. First, withdrawal. Secondly, revocation. Okay. So an offer may be withdrawn or the offer may be revoked. You may get a feeling about it. These two words seem to be the same. These two words seem to carry the same meaning. Of course, it's carry the same meaning, but CiSG intends to use these two words, okay, to carry the in fact, the meaning at different stages. Okay, when an offer has been made, if the offer has not yet reached the offeree, in that case, CiSG allows the party to put an end, an end to an offer by withdrawing an offer. So the word, withdrawal, it is used at the stage where an offer has been made, but the offer has not yet reached the offeree. But if the offer which has been made has already reached the offeree, then in that case, CiSG does not use the word withdrawal anymore. Okay, CiSG uses the word revocation. If the offer has been made from A to B and the offer as made by A has already reached B, in that case, A can just put an end, to the effect of the offer by revoking an offer. Okay, so you can see that there are two stages. Okay, and CiSG uses different words. Okay, to describe different stage. If you are at a stage of, at a stage where an offer has been made without reaching the offeree yet, okay, then you can just withdraw your offer. But if you have made an offer and that offer has already reached the offeree, then you can just revoke your offer. Okay. Now, okay, we come to the first stage, the stage where an offer has been made to an offeree. Okay, but the offer has not yet reached the offeree. A has made an offer to B. The offer has been made by A, but the offer has not yet reached B. In that case, A can withdraw his own offer. Okay, so A can just make use of Article 15, 15.2, okay, 15, the paragraph 2, which provides as follows. An offer, well, I try to just use the word 15, paragraph 2, but some people may read it as 15, subparagraph, subsection 2, okay, but in our country, okay, normally, if we talk about the paragraph like this, okay, we use the word paragraph. Okay, the subsection in this country, it is part of the paragraph, but in the foreign law, including in CiSG, okay, when they begin the paragraph, okay, they just put in parentheses, okay, like 15 in the parenthesis 1, that is 15 paragraph 1, but some people may just call it as 15 subsection 1. Fine, okay, whether you just call 15 subsection 1 or 15 paragraph 1, okay, please just understand that, that is the same thing, okay. So according to 15 paragraph 2, an offer, even if it is irrevocable, an offer may be withdrawn if the withdrawal reaches the offeree before or at the same time as the offer. Let's mean that A has sent an offer to B, but the offer has not yet reached B. In that case, A may change his own mind. A can just withdraw his offer, okay, but he has to make sure that his withdrawal reaches B, okay, just before the original offer, or at the latest at the same time as the original offer. If the offer as made by A has reached B, then it's too late, okay, to just apply Article 15, 15.2. Okay, in that case, if A wants to put an end to his offer, he has to make use of Article 16.1. Okay, he has to do what? He has to revoke the offer. Okay, if the offer has reached the offeree, if the offer has reached B, then A can no longer apply Article 15.2. A can apply Article 16.1 in that case. Okay, now back to 15.2. Okay, so again, if A has made an offer to B and the offer has not yet reached B, A can change his mind, okay, by revoking the offer. But he has to make sure that his revocation, I made a mistake. A can just change his mind by withdrawing his own offer, but he has to make sure that his withdrawal reaches the other party just before his original offer, or at the latest at the same time as the original offer. Okay, that is something quite clear. I think that you can also see, the similar position even in Thai law in the civil, and Commercial Code of Thailand in section 169. Okay, 169 talk about the declaration of an intention. Okay, when the two parties, when the two parties are not in each other's presence. Okay, in that case, the person who declared an intention may just may just put an end put an end to his declaration of intention. Okay, but he has to make sure that but Thai law uses the word revocation. He has to make sure that that his revocation his revocation will reach the other party. Before or at the same time. Okay, before or at the same time. See, so something similar to what you see in CiSG. Okay, if you want to change if you want to change your mind, you need to make sure that your new declaration of an intention, reaches the other party before the original, intention, or at the same time as the original declaration of an intention. Okay, so what you see in Article 15.2, it is something similar to Section 169 of Thailand's Civil and Commercial Code. Okay, now as I have mentioned, if A has made an offer to B and the offer as made by A has already reached B, if it has already reached B, in that case, A can also put an end to his offer by revoking his offer. Okay, so according to Section 16.1, until a contract is concluded, an offer may be revoked if the revocation reaches the offeree before he has dispatched an acceptance. That means that if A wants to change A's mind, A can just revoke his offer, but A has to make sure that he does so just before B dispatched an acceptance. Okay, if B has dispatched an acceptance, then it's too late for A to revoke, the offer. Okay, A has to be bound by his own offer. Okay, so the rule is that an offer made by a party is revocable. Okay, but the party needs to make sure that the revocation reaches the other party, the other party before the other party dispatch an acceptance. Okay, but there is also exception. Okay, an offer may not be revoked if it is indicated as irrevocable. If A indicates that his offer is irrevocable, then he cannot revoke his offer. He can indicate that it is not revocable by fixing the term for acceptance. If A sends an offer to B and he just expresses in his offer that this offer is open for, let's say that, for 7 days. That means that within this 7-day period, he cannot revoke his offer. Okay, by stating a fixed term for acceptance by the other party. That is the indication of revocability. Okay, if A just fixes a term for B, the term within which B needs to reply or needs to send acceptance. Okay, in that case, the law take it that A expresses an intention not to revoke an offer within that period of time. Okay, or A may just indicate his intention, not to revoke an offer, by some other conduct. Okay, of course, fixing the term for acceptance, it is something which is understood as an intention not to revoke an offer. But in addition to fixing the term for acceptance, A can also expresses his intention not to revoke an offer. Okay, by any other means as well. And another exception is this one: if it was reasonable for the offeree to rely on the offer as being irrevocable, then the offeror cannot revoke his offer, even though he does not, even though he does not indicate that his offer is not revocable. Okay, but I mean, it was reasonable for the offeree to rely on the offer as being irrevocable. That means that there must be, some circumstances which gives, give the reliance on the part of the other party, i.e., on the part of B, if A makes an offer, okay, and it was reasonable for B to rely on, the offer as being irrevocable. Okay, there may be some circumstances which which leads B to believing that the offer is not revocable. In that case, mean the offer made by B is not revocable. Okay, if you consult, the digest pertaining to the CiSG, you can see that when Article 16.2b say something about about when section 16.2b say that it was reasonable for the offeree to rely on the offer as being irrevocable. The digest say that this is something to do with the estoppel. Okay, estoppel. This means that there are some circumstances which estopped A from the revoking his offer. Okay, there are some circumstances which lead the other party, i.e. B, to believing that the offer made by A is not revocable. Okay, so we in our law in Thailand, we have also something similar. Okay, if you look at section 354 and 355, okay, you can also see something similar to what we have seen in the Article 16 of the CiSG. According to section 354 of our CCC, the CCC of Thailand, okay, an offer which is an offer to make a contract in which a period for acceptance is specified cannot be withdrawn within such period. Okay, this is similar to Article 16.2a of the CiSG, and according to Section 355 of the Civil and Commercial Code of Thailand, a person who has made an offer to another person at distance without specifying a period of time for making an acceptance may not withdraw his offer within the time in which a notice of acceptance is reasonably expected to be received. That means that if A make an offer to B and A and B, the A and B are as distance, they are not in each other's presence. Okay, when A has made an offer to B, even though A has not specified a period of time for B to make acceptance, okay, A will have to give B at least, a reasonable time. Okay, A cannot withdraw his offer within the time in which a notice of acceptance is reasonably expected to be received. Let's say A is in the city in city A and B is in city B, which are quite far from city A, right? Oh, A in city X and B in city Y, okay? And the city X and city Y are very far from each other. Okay, let's say that it will take about 3 days. By post. Okay, 3 days by post. If A makes an offer to B, okay, when A sends his offer, of course it will take 3 days for a letter from A to reach B. Okay, and of course it will also take 3 more days for a letter from B to reach A. So, and then when A has made an offer to B, A needs to give B at least, I think that about 7 days, okay? 3 days for a letter from A to reach B, and another 3 days for a letter from B to reach A. and maybe one day for B to think about it. Okay, at least A will have to give B 7 days. Okay, 7 days. This is a reasonable period. It is a reasonable period. The reasonable time in which a notice of acceptance is reasonably expected to be received from B. Okay, so within this, the 7 day period, A cannot withdraw his offer. So you can see that the law of talent also, has something similar to what we have seen in the CiSG. Now, okay, before we end this, the topic, okay, again, I'm trying to give you, the summary again, okay. CiSG fixes, the two stages of time. Okay, in order for a party to put an end to an offer, if A has made an offer to B without A's offer having reached B, A in that case can withdraw his offer, but he has to make sure that his withdrawal, okay, reaches B before the original offer, or at the latest at the same time as the original offer. Okay, but if the offer as made by A has reached B already, in that case A can just revoke his offer. Okay, but he has to do so just before B has dispatched B's acceptance. Okay, that is something which is the said in the CiSG in the Article 15 and Article 16. Okay, if you have time, you can go and have a look at the wording. Okay, clear wording in Article 15 and Article 16. Now we move on to a very, very the important part. We will move on to the modified acceptance and the battle of forms. Okay, just at the beginning, okay, we have seen that CiSG, okay, resorts to the meeting of the minds, in the sense that there must be the meeting between an offer and an acceptance. Remember, an acceptance must match the offer completely. So CiSG, the CiSG just, of course, to focus on the meeting of the minds. Okay, we have the rule that an acceptance must meet the offer completely. Okay, so that if an acceptance differs from the offer, then it is, as I have mentioned at the beginning, okay, it is just a qualified acceptance. Okay, so if your acceptance, if A makes an offer to B and B's acceptance differs from A's offer, that is a qualified acceptance. Okay, so it is not a contract. Okay, so the traditional rule is that an acceptance must match the offer completely. Okay, so when the acceptance must match the offer completely, this is sort of the mirror image. It's like when you look at the mirror. Okay, if you look at the mirror, what will you see? What will you see in the mirror? If you look at the mirror, you will see yourself. Correct. If you look at the mirror, you will see yourself. That means that you input yourself and then you will have to see yourself. Okay, so the mirror image rule, it is in the sense that, okay, if A makes an offer, B must make the acceptance which is identical to an offer, as if, okay, in the same way as as the picture which you see from the mirror. You input, you just, project yourself into the mirror. And then, as a matter of reflection, you will have to see yourself. So in the same way, if A makes an offer, okay, B needs to accept the offer. B's acceptance needs to match the offer. B's acceptance needs to be identical to an offer in all respects. Okay, in the same way as in as much the same way as we see the mirror, the image. So this is the traditional approach. Okay, the traditional approach has been adopted in many countries, including in this country, in Thailand. Okay, but we have to be aware that, okay, attempts have also been made okay, in the law of many countries to introduce a modern approach. The modern approach is the material alteration approach. Okay, even though an acceptance differs from the offer. Okay, uh, that acceptance may be still regarded as acceptance. Okay, not a counter offer if if what? If the difference it is not material, if that difference does not does not materially alter the terms of the original offers. Let's say that when A makes an offer to B makes an acceptance. Okay, even though B's acceptance contains something which is different from A's offer, if the difference does not materially alter the terms of the original offer, then the acceptance made by B, it is still regarded as the acceptance, not as a counter offer. Why do the lawyers in many countries switch from the traditional approach to the modern approach? Okay, the reason is something to do with the use of the form in the business. The switch to the modern approach, okay, the material alteration approach, okay, is to serve business efficacy, okay, because in real practice in business, usually parties do use their own form, okay, maybe the business form, the form used in their business, okay. Let's say that we have A and B. A also use A's form. B also use B form. When A makes an offer, okay, A makes an offer using A's form. A's form may contain some clauses. When this form used by A is sent to B, maybe B did not look at A's form carefully. B may just look at some part. Let's say that B just look at the price. Let's say that A form is the price quotation. Okay, A makes the price quotation using A's form. Of course, this is an offer made by A. Okay, this is an offer made by A. Let's say this offer is the price quotation. Okay, when A send his price quotation to B using his own form, okay, when B received A's offer, okay, when B received A's form, B probably did not look at all clauses, okay, that contained in A form. B looked at only the part which mentioned the price, right? So that when B did not look at other parts very carefully, okay, they did not have a full glimpse of A's offer, right? B, let's say that B is happy with the price quoted by A, and B wants to make an order. Maybe B used B's own form. Let's say the order form. Okay, the order form. B sent an order form to order the goods. Of course, this order form, it is the acceptance. Okay, and let's suppose that B also uses B's own form. Maybe B's own forms contain some clauses, right? A, in his own form, he mentioned that the contract will be formed subject to A's form. Okay, A form. B also say the same thing. B may say that the contract is going to be made subject to B's own form. Okay, so A says that the contract is made, okay, on the basis of A's form. Similarly, B also says that the contract is made on the basis of B's form. So the two parties, they have the battle of forms. That means that both parties, each party try to say that each party try to claim that the contract is full on its own terms and conditions. They have a fight over the form. A say that the contract is subject to A's form. Similarly, B say that the contract is subject to B's form. Then we have to determine on whose form is the contract concluded. Okay, the contract is concluded on the basis of whose form, A's form or B form. Right. If we, if we resort to strict application of the traditional approach, the approach which maintains that an acceptance need to match the offer completely, the mirror image rule, then we will in some cases encounter some problems because there is high possibility that B's form differs from A's form. B's form differs from A's form in some way. Maybe the difference seems to be very minor. Maybe the difference seems to be very slight. But if we resort to the traditional approach, then we might end up with concluding that there is no contract because A's form and B's form differ. Clauses or terms and conditions on A form and terms and conditions on B form are not exactly identical. So when B's acceptance is not identical to A's offer, then there is no contract. See? So the strict application of the traditional approach rule might lead to absurdity in the sense that a contract might not be formed, even though sometimes the two parties have gone ahead with the contract. On a good day, one of the party may argue that, the contract is not formed because the offer and acceptance did not just meet completely, did not just match completely. Okay, so that's why if any party argue this way is going to do what? It's going to harm business. It does not promote business. It does not give efficacy to business. That's why the laws in many countries switch from the traditional approach to the modern approach, the approach which is based upon the material alteration, which we are going to go to shortly. Okay. Now back to the traditional approach. If you look at this approach, let's suppose that A's form consists of clause 1, clause 2, clause 3, and clause 4. B's form, when A make an offer, using A's form consists of clause 1, clause 2, clause 3, and clause 4. When this form is sent to B perhaps did not, pay attention to A's form very well. B also used B's own form. Let's suppose that in essence, B's form also contains some clauses consisting of clause 1, clause 2, clause 3, clause 4, which are in essence in line with clauses 1, 2, 3, 4 on A's form. But B's form also contains clause number 5. Clause number 5, which is an additional clause. If we stick to the traditional approach, we can just say that, well, in this case, A makes an offer and B makes an acceptance, which differs from an offer. So that this document used by B, it is not an acceptance because it contains something different. So it is a counter offer only. When it is a counter offer only, that means that there is no contract unless A accept this counter offer. So even though A and B sometimes they have gone ahead with the contract on a good day, one of the party may argue that if they want to escape the contractual obligations, okay, they may say to the other party that, oh sorry, there is no contract between us because there is no meeting the minds because I offer one thing but you accept something else. Okay, you make your acceptance with some modification so that it is just a counter offer and I have never accepted your counter offer so that there is no contract between us. Okay, so there is possibility of this kind of argument. Okay, so that's why if there is this kind of argument, then the business may be ruined. Okay, that's why the law does not want this situation to occur. Okay, so the law tries to prevent formation of contract by switching to the new approach known as the material alteration approach. According to the new approach, okay, even though an acceptance differs from an offer, even though an acceptance contains a different terms or an additional term, if the difference term or additional term is not material alteration, okay, of the original offer, then it still operates as an acceptance, not a counter offer. In order to facilitate your understanding, okay, let's have a look at this this picture again. We have A and B, and supposing that both parties, both A and B, use their own form. A has A's form, B has B's form. A's form contains clause 1, 2, 3, 4. When A sends this form to B with an indication that a contract which is formed in the future will be formed on the basis of A's form only. When this form is sent to B, B did not look at A form. B also used B's own form. Let's suppose again that B's form consists of clause 1, clause 2, clause 3, and clause 4, which in essence are in line with A's form, but B's form also has clause number 5. Clause number 5, it is an additional term. Okay, in this case, we will have to look at the substance of this clause number 5. If clause number 5 does not materially alter the term of the offer, if clause number 5 is not a material alteration of the offer, then the document used by B operates as an acceptance nonetheless, not a counter offer. So when we have an offer, okay, from A and an acceptance from B, that means that we have a contract between A and B. Now you may ask the question, well, when there is the clause number 5 here, the contract is formed between A and B with or without clause number 5. Is clause number 5 included as part of the contract between A and B? Well, on this question, okay, it depends. In some jurisdictions, and I should say that this may be the prevailing view adopted, prevailing position adopted in, the majority of countries, okay. In most countries which adopt the material alteration approach, they regard, this additional term or different term as part of the contract as well. If A does not object, then the contract is formed between A and B. If A does not raise objection to the different term or the additional term, okay, which is introduced by B. In this case, okay, the contract is formed. Also, okay, with clause number 5 here, or with the additional clause or different clause being regarded as part of the contract as well. So in this case, A's form contains clause 1, 2, 3, 4. B's form contains clause 1, 2, 3, 4, and 5. When we look at the contents of clause 5 and we see that clause 5 does not materially alter clause 1, 2, 3, 4 used by A, then the contract is formed between A and B with clause 1, 2, 3, 4, and clause number 5 as well. Okay, but in some countries, in a few countries, they use the so-called knockout rule. The contract is formed between A and B only to the extent of identical terms. So in this case, the contract is formed by A and B. I mean, there are 4 countries which adopt the knockout rule. The contract is formed between A and B. Okay, with clause number 1, clause number 2, number 3, and number 4. Okay, just the identical clauses. Now, if you look at the CiSG, you can see that CiSG also has this new approach, the material alteration approach. If you look at section 19, article. Sometimes I just have the habit of using the word section. Okay, CiSG uses the word article, not section. Okay, in our country we use section. In Article 19, in paragraph 1, okay, paragraph 1 say that you may call 19.1. Some say 19 paragraph 1, some say 19 subsection 1, so depends. 19.1 says a reply to an offer which purports to be an acceptance but contains additions, limitation, or other modifications is rejection of the offer and constitutes a counter offer. So if you look at paragraph 1 here, it is just a what? It is just a traditional approach, the mirror image rule. If an acceptance contains some addition, limitation, or any other modification, that means that it differs from the offer, so that it is the rejection. See, the contract is not formed. But paragraph 2 or 19.2 goes on to state this. However, a reply to an offer. A reply to an offer which purports to be an acceptance but contains additional or different terms which do not materially alter the terms of the offer constitutes an acceptance. See, so even though the acceptance contains something different or something additional to the offer, it is still an acceptance unless the offeror without undue delay objects. Only unless the offeror without undue delay objects orally to the discrepancy or dispatches a notice to that effect. If he does not so object, the terms of the contract are the terms of the offer with the modification contained in the acceptance. That means that if we come back to this picture, A makes an offer consisting of clause 1, clause 2, clause 3, and clause 4. B makes the acceptance containing clauses 1, 2, 3, 4, which are identical to clauses 1, 2, 3, 4 on A's document. But B's document also it introduces clause number 5. B adds clause number 5 here. If clause number 5, if we go back to the paragraph 2 here, if clause number 5 does not, materially alter the term of the offer, then the document used by me here, constitute an acceptance nonetheless, and clause number 5, the modification, which is embodied in clause number 5, is part of the contract as well. The contract is formed together with the modification contained in the acceptance. This is the position in Article 19.2 of the CiSG. So in a way, CiSG introduces the model approach, the material alteration approach, under which an acceptance still operates as acceptance even though it contains some modification if the modification does not materially alter the term of the offer. Then it is still an acceptance and the contract is formed together with the modification, unless the overall objects without undue delay. So now we have to look at this question. When CiSG introduced the model approach here, the material alteration approach, is that illusory? Is that illusory or real? That's why do I say that? Is that an illustration in illusion or reality? Because if we goes on to read paragraph 3 on the same article 19. If we look at 19.3, it says this: additional or different terms relating among other things to the price, payment, quality, and quantity of the goods, places and time of delivery, extents of one party liability to the other, or the settlement of dispute, are considered to alter the terms of the offer materially. That means that if the acceptance contains something regarding the price, the payment, quality, quantity, place and time of delivery, extents of the parties' liability, settlement of dispute, all these matters are considered as material, so that the paragraph 2 does not apply if these matters are found in acceptance. If the acceptance contains something different or something additional in respect of these matters, then that is the material alteration, so that is not regarded as the acceptance. It will rather be regarded as a counter offer. Well, when paragraph 3 or 19.3 say that all of this are material, what is left apart from this? It seems that nothing is left. Everything everything is mentioned in paragraph 3 here. Will it produce the consequence that the modern approach, the material alteration approach, which is stated in Article 19.2, it is not real. It has no room for application because everything seems to be material. So that we have no room for applying paragraph 2 at all. Right. So some might say that, well, paragraph 2 or 19.2 may perhaps be just, illusory, okay? So, but that is not true. If we go to the wordings, if we are so strict, okay, about the wording of 19.2, we may come to the conclusion that everything every modification will similarly be material. But if we consult the digest to the CiSG say that no, this matter, even though we have some matters in the 19.3, it does not mean that modification with respect to this matter will always be material. We still need to look at the content. Okay, so the digest say that well, the language will state the price. The language will state that the price would be modified by increases or decreases in the market price. This is something not material. So if A makes an offer and B accepts A offer with the modification like this, it is not material alteration. It may still operate as an acceptance. See. Also, the term which reserves the right to change the date of delivery, this is the modification which is not material. The term which alters the shipping time but not the delivery time, this is immaterial alteration. The modification of transport cost may be regarded also as immaterial, or the adjustment of the quantity of the goods in each delivery without changing the total amount. This is something not material. Okay, and even the deletion of a liability clause for contract violations. Okay, the digest also say that this may be something immaterial, so that we still look at the substances of the modification, even though the modification, okay, is made with respect to the matters expressed in Article 19.3. We cannot just readily conclude that those modifications are material. Okay, we still look at the contents. Okay, so that the digest, okay, tell us, the CiSG digest tell us that even that we come across the matters in 19.3, even in the case where an acceptance contains some modification with respect to the matters in Article 19.3, okay, it may be the alteration which is not material, so that okay, the acceptance may still operate as the acceptance rather than a counter offer. Apart from finding this modern approach, the material alteration approach in the CiSG, we can also still witness this in American law in UCC, Uniform Commercial Code, in section 2207. If you have time, you can go and have a look at Article 2207. We can also see this one even in the Uniform Principles of International Commercial Contracts. The current edition is 2016 edition. Okay, so the wording as used in the Uniform Principles of International Commercial Contracts 2016 seem to be very, very similar. The similar to what you see in Articles 19 of the CiSG. See, if you look at the wording in paragraph 1, a reply to an offer which purports to be an acceptance but contains additions, limitations, or other modifications is a rejection of the offer and constitutes a counter offer. But paragraph 2 goes on to say, however, a reply to an offer which purports to be an acceptance but contains additional or different terms which do not materially alter the terms of the offer constitutes an acceptance, unless the offeror without undue delay objects to the discrepancy. If the offeror does not object, the terms of the contract are the terms of the offer with the modifications contained in the acceptance. So this is based upon the the modern approach, the what material alteration approach, and it is not based upon the knockout rule. Okay, so this is the similar position to the one in Article 19 of the CiSG, now titled, do we have this new approach? Do we have this traditional approach? Sorry, do we have this modern approach? In title, if you look at section 395, it says, it provides as follows. If the acceptance of an offer arises out of time, it is deemed to be a new offer. And paragraph 2, which is something important, paragraph 2 says, an acceptance with additions, restrictions, or other modifications is deemed to be a refusal coupled with a new offer. See? So according to the section 395 of the Civil and Commercial Code, if A makes an offer using the document containing clause 1, clause 2, clause 3, clause 4, and B accepts A's offer using B's own form, containing clauses 1, 2, 3, 4, which are the same as clauses 1, 2, 3, 4 on A's document, but B's document contains clause number 5, then whether or not clause number 5 materially alter the original terms of the offer made by A, B's document constitutes a new offer or a counter offer, not an acceptance anymore. And we do not have any provision similar to Article 19.2 of the CiSG, so that the modern approach or the new approach, the material alteration approach is not known to Thai law. Okay, it is not known to Thai law. As I've mentioned, okay, the modern approach in fact gives business efficacy, so we need to perhaps consider whether or not time is right for us in Thailand to introduce this new approach, the material alteration approach in the CCC. But we have to bear in mind as well that CCC applies to all contracts, whether commercial contracts or non-commercial contracts. So when we have seen that this new approach, the material alteration approach, is intended to give business efficacy, I think that means we should be inclined to think that this, if we want to introduce this new approach, the new provision, okay, introducing this new approach should apply only to commercial contracts rather than all contracts. Maybe I leave this method to you for your further thinking. Okay, whether or not time is right for us to amend our civil and commercial code of Thailand. Okay, to the effect of having the new approach, the material alteration approach. Okay, which will give business efficacy. Okay, so I think that means time is right for us also to end the lecture now. Okay. So today we have the lecture consisting of part one and part two. Part one, it is contained in the clip or the file which I have recorded and will make it available on YouTube. Okay, and now part two. Part two is the part. The part two is this part, okay, so which you are now viewing, okay, the live on Facebook, and I also record this lecture, and also I'm going to upload this file onto YouTube, okay. Even though you have seen it, but you can just you can just view it at any time, okay. And I'm sure that if I just upload this file on YouTube, okay, onto YouTube, then the public, will read it as well, and it's going to be useful to the public as well. Okay, that is for today, and now very tired. Okay, because I have lecture for I think that more than 3 hours. Okay, today, uh, in the first half of the lecture and the second half of the lecture. Okay, so I hope that you find something useful from my lecture, and we will see again, okay, next week. Of course, I think that we will spend one more session on CiSG before we just move on to some other topics. Okay, so hopefully you enjoy my lecture tonight. Okay, this evening. Thank you very much for your attention. Okay, and see you next week. Thank you. Bye bye. Bye bye.